it seems like yours is going to be raised by you as a single mother and him. And they're going to be calling another woman stepmama at the rate you're going because you're too busy. And everybody business, and you're not paid to be in that business. I'm paid to be in people business. You're not paid to be in people business. Okay? You not paid. I get paid. This is what I do. It's given that you want to be a blogger. That's why you stay heavy in the blog. You want to control our news because secretly, deep down, that's what you want to do. You want to be a blogger. You want to be the media.
Woohoo. Girl, let me get my screen straight. Oh my God. Is it so? Hey guys, how are you? What's going on? Who said, is this my imagination? No, it's not your imagination. Girl, okay, I got some tea. Straight up and down, I got some tea. It's really some facts. It's not even just tea. It's straight up and down. Just this is what it is. Okay. And we're going to get right into it right now. Okay. Um, If you're on the replay, welcome. Hit the like button. Likes do matter. Okay. I felt obligated. I was in a live and I was over on Real Talk Bougie and I was in the middle of dropping some other tea. And then I got an alert because that's what I use my automation. My alert went off from Fulton County, and it gave me an alert saying that the Attorney General of the state of Georgia dropped some paperwork on a mommy from the YouTube streets. And I was like, oh shit, do I do this over here? Do I do this over there? Because it is a legal document. And I'm like, ugh, I'm in the middle of a live that has nothing to do with this. Just forget about it for a minute, right? I get off my live and I was reading as I was doing something else, which I'm typically doing. And I just said, I can't. This was filed at 3. Well, I guess it was filed into the clerk of courts at 3:42 on 4/25. However, it dropped into my preview while I was doing this live earlier today. So this must have been filed on Friday. This is very interesting, and I feel like this is going to answer some questions we had on the YouTube streets about what's this have to pay $5,000 for? You know what I mean? I just feel like this. If some people talk less, I think sometimes stuff shows up less. Okay, let's get into it, guys. The state of Georgia, the Attorney General, the top lawyer in Georgia, baby, has something for Keisha and Jeremy LLC. Okay, baby. Pursuant to the Fair Business Practices Act, FBPA, Christopher M. Carr, Attorney General of the state of Georgia, by and through Consumer Protection Division, has initiated an investigation and examination of certain acts and practices of Keisha and Jeremy and Keisha Anderson individually to resolve the issues that they are the subject of this investigation. These parties are willing to enter into an assurance of voluntary compliance pursuant to OCGA 10-1-402. I'm not even looking at the comments, y'all. I'm not even going to look because I got to cook dinner. So I got to be expeditious in these efforts. But I said, I got to come for my boo-boos and my bebes because this is it. Okay. So you guys talk to each other. Dun, dun, dun. Okay. Investigation and examination. This explains the $5,000. Okay. It is therefore stipulated and agreed as follows. This is the general terms. Okay. Listen carefully. Respondents have engaged in consumer transactions, acts, or practices in the product of trade or commerce in part or wholly within the state of Georgia as defined by OCGA 10-11-392. Respondents market its credit repair business in Georgia and other states nationwide. That's practices include credit consulting, advising, credit repair, and the sale of credit repair educational and training materials. Keisha Anderson, owner of KAJ, a YouTube content creator and influencer, also known as Keisha Kaylee, who also offers credit repair services through her various social media platforms. KAJ is a registered Georgia limited liability company with a principal place of business at, I redacted, KAJ may be served at its principal place and through the owner, organizer, registered agent Keisha Anderson, who individually and in her representative capacity may be served at her residential address. Respondents consent to the personal jurisdiction of the Superior Court of Fulton County and acknowledge the subject matter jurisdiction and venue in connection with issues involving the subject matter of this assurance are proper and shall lie in the Superior Court of Fulton County. The Attorney General contends that respondents have engaged in unfair or deceptive acts or practices during the course of consumer transactions in trade and commerce as declared unlawful by the FBPA. Specifically, the Attorney General alleges that respondents engaged in the following. Okay, this is what they say y'all did: illegally operating a credit repair organization in Georgia as defined by OCGA 16959, sub A 2A, without falling within one of the statutory examples as set forth in OCGA 16959 A2B, and therefore representing illegal services as legal services that respondents are not authorized to provide in violation of OCGA 10-1-393, offering and providing to Georgia consumers services to improve their credit record, history, and or rating without lawful authorization to do so in violation of OCGA 10-1-393 sub A, receiving money or valuable consideration for the performance of a variety of services related to credit repair that respondents agreed to perform for consumers before the services were fully performed, prohibited by 15 USC 1679B and the FTC's telemarketing sales rule 16 CFR 310.4 in violation of OCGA 10-1-393A. Pursuant to OCGA 10-1-397B and 10-1-402, which provide an assurance of voluntary compliance, shall not be considered an administration of violation of the FBPA for any purpose. Respondents hereby enter into this assurance to resolve this matter without necessity of formal legal action. Respondents specifically deny, the respondents specifically deny that they have violated any statute or regulation. The respondents, that's Keisha and Jeremy, LLC. Respondents specifically deny that they have violated any statute or regulation. Acceptance of this assurance by the Attorney General does not constitute approval of any of respondents' business practices by the Attorney General. Just because you are accepting this deal that we're giving you doesn't mean that we also put you in the clear for what you got going on over there. We're in contact with you for a reason. What you're doing is against the law. I'm paraphrasing. In acceptance of this assurance, the Attorney General hereby agrees to not initiate further legal action against respondents concerning the matters covered in this assurance. So, this deal we're giving you, we're not pursuing any additional legal action if you heed to this, basically this deal, this contract that we're giving you, basically subject, however, to these provisions and contingent upon respondents' full compliance with all the terms and conditions set forth herein. Upon breach of any of the provisions of this assurance by the respondents, their employees, agents, successor business enterprises, the Attorney General reserves the right to pursue any action under OCGA 10-1-310 against respondents concerning the subject matter of this assurance. Y'all following? Respondents expressly acknowledge their awareness and understanding of the guidelines and prohibitions contained within the FBPA. Remedial measures. Effective as of the date of the execution of this assurance by the Attorney General, respondents, as well as subsidiaries, members, directors, officers, agents, employees, representatives, and servants, shall comply with the following. Respondents shall act in full compliance of FBPA, full compliance with the FBPA, all conditions of this assurance, and any other applicable laws. Respondents shall ensure that they are not engaging in any unlawful activities defined as credit repair services organization pursuant to OCGA 16959, including but not limited to what respondent refers to as credit consultations, credit repair, and or offering products, including but not limited to trade lines that are used to improve credit scores in the state of Georgia. Whether respondent remains in Georgia, move their business operations, or conduct business outside of the state of Georgia, they shall not advertise, offer, sell, engage in credit repair services in the state of Georgia. Period. Shall not advertise, offer, sell, provide credit repair services to Georgia residents. Shall not engage in any acts or practices, either expressly or implied, that create the perception that it offers or provides credit repair services in the state of Georgia or Georgia residents. Shall not engage in any acts or practices, either expressly or implied, which create the perception that it will require or voluntarily accept payment, whether in the form of costs, fees, or donations for any credit repair services in the state of Georgia and or provided to Georgia residents. Shall not state directly, indirectly, or create the perception that that is offers, sells, facilitates, or otherwise provide credit repair services in the state of Georgia or to Georgia residents in any other website advertisement in whatever form those advertisements exist, including but not limited to internet advertisements, telemarketing, direct marketing, print media, broadcast media, support media, social media, sales or training presentations, or sales calls shall clearly and conspicuously state credit repair and credit restoration services are not available to Georgia residents in all of its websites and all of its advertisements in whatever form those advertisements exist, including but not limited to internet advertisements, telemarketing, direct marketing, print media, broadcast media, social support media, social media, sales presentations and or sales calls, and shall clearly conspicuously place the following statements on all applications, contracts, receipts, bills, invoices used by the respondent. Credit repair and credit restoration services are not available to Georgia residents. Respondent shall not own, operate, or be affiliated with credit repair services organizations that advertises, offers, sells, provides advice or assistance with regards to represents that can be performed or actually performs credit repair services for Georgia residents or otherwise does business in the state of Georgia. While present in the state of Georgia, respondent Keisha shall not participate in any way in the operation of any credit repair services organization. Respondents shall not state directly, indirectly in any advertisements or websites that respondents sell products, provide advice, or provide assistance of any kind, including but not limited to actual acting as a referral service to other persons or credit repair organizations regarding improving a person's credit history, record, or rating in the state of Georgia. Respondents shall, within 10 business days of the assurance execution, conspicuously place the following statement in at least 12-point boldface font on every page of respondents' websites, contracts, and all advertising or promotional materials used by respondent. Credit repair restoration services are not available in the state of Georgia. It's not available to Georgia residents. That's embarrassing. Y'all, within 10 days of this particular report, you're going to use a 12-point boldface font on every page of respondents' websites, contracts, and all advertising or promotional material used by respondents. Credit repair and restoration services are not available to Georgia residents. Respondents must respond in a timely manner, but in no case later than 10 business days, to all inquiries for CPD related to the subject matter of this assurance. Such requests by CPD may be made to respondents via email to Keisha Anderson at, and it's her regular business email, but I covered it up. The failure of respondents to respond to any inquiries from CPD related to the subject matter of this assurance will be in violation of this assurance. The Attorney General determines whether there is a violation of this assurance. For a period of 2 years from the date of respondent signing this assurance, respondent shall notify the Attorney General in writing of any of the following: any change in either of the respondent's names, aliases, residence, or business mailing address, electronic mail address, telephone numbers within 7 days of such change. Any change in respondent's affiliation with any other entity within 7 days of such change. to the extent that Keisha Anderson is no longer the proper individual to accept service of process on respondents within 7 days designate a new individual to accept service of process on their behalf and notify the Attorney General in writing of the new individual, as well as provide the individual's mailing address and phone number. Notice under paragraph X or 10 shall contain the name, address, and purpose of each person and entity that has changed, including the name, address, purpose, and any entities newly affiliated with, performing services for, and doing business with either of the respondents for the purpose of change, penalties, and fees simultaneously with the execution of this assurance. Respondents shall jointly and severally pay the following. Here's what you guys want to know. Respondents will pay $15,000.00 to be used by the Attorney General's office for the purposes that may include, but are not limited to, civil penalties, consumer restitution, attorney's fees, and other costs of investigation and litigation, or to be placed in or applied to any consumer protection law enforcement fund, including future consumer protection or privacy enforcement, privacy education, litigation, local consumer aid fund, and revolving fund used to defray the costs of the inquiry leading hereto, and for other uses permitted by state law at the discretion of the Attorney General. Respondents shall make said payment by wire transfer, certified check, money order payable to the Georgia Department of Law and delivered to Irenata Duncan, Assistant Attorney General, Georgia Department of Law, Consumer Protection, blah, 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 Georgia, Atlanta. Upon submission of the assurance to the Attorney General no later than April 25th, payment shall be made in installments as follows. The first installment, $5,000, shall be paid upon submission of the assurance to the Attorney General. That's one. The final payment of $10,000 shall be paid by the respondents no later than April 7th, 2027. So they have 2 years to pay 10 grand. They had to pony up with 5,000 right away, and then 10,000 by April 7th of 2027. Respondents shall not be required to pay the final installment if the following conditions have been met by 5 p.m. Okay, wait a second. Respondents shall not be required to pay the final installment if the following conditions have been met as of 5 p.m. Eastern Time, April 1st, 2027. Okay, so they made the first payment, which is obvious. She made that, right? So if they follow these directions, this is going to save them 10 grand. Okay. The Attorney General determines that the respondents have not defaulted on the terms of the assurance by violating any provision. So as long as you follow these next rules, I'm going to say they're not going to have to pay the 10 grand in the next 2 years. Okay. So number one was that they haven't violated, which I feel like that happened already. Didn't she give away some free credit repair services in her last episode? The Attorney General has not received any additional verifiable, actionable complaints. Baby, boom. Okay. The Attorney General has not received any additional verifiable, actionable complaints that implicate violations of this assurance and are attributable to the respondents, their agents, employees, independent contractors, representatives for a period of 2 years from the effective date of this assurance. And the Attorney General has received the respondents' certification under penalty of perjury, and the respondents have fully complied with all provisions of the assurance and a request that the final installment be waived. Said certification and request shall be submitted to the Attorney General no later than March 15th, 2027, and no later than March 31st, 2027. If the Attorney General determines that all conditions for waiver have been met, he shall notify respondents through business owner Keisha Anderson via email on April 5th, 2027. The payment of the final installment has been that it would have been waived. Notwithstanding or foregoing, and for the avoidance of doubt, the final installment shall be deemed to be waived unless the Attorney General notifies the respondents on or before April 15th of a default in accordance to Section 7. Oh, excuse me, Section 12, my bad. If respondents fail to comply with any provision of this assurance, the entire amount for all payments described in Section 11 that have not already been paid as required under the insurance shall become immediately due and payable to the Attorney General's office. Respondents shall be required to immediately remit the balance to the Attorney General in the form as provided in Section 11, Paragraph A. The Attorney General determines whether the respondents have failed to comply with any provision in the assurance. Respondents acknowledge that the obligation imposed in Section 11 are not a fine payable to the state of Georgia, and they are therefore not subject to be discharged or set aside in any proceedings filed under Title 11 United States Code pursuant to provisions. Any submission of this assurance to the Attorney General and filing fee of the amount of $125.00 shall be paid by wire transfer as a preferred method or by cashier's check, certified money order to the Department of Law. Default procedures. In the event the Attorney General believes respondents are not in compliance with any of the provisions of the assurance and therefore considers the respondents in default of the provisions, the Attorney General shall provide notice to the respondents identifying respondents' actions that constitute default of the provisions of the assurance and shall provide respondents 10 business days to explain why the default has occurred. The default notice shall be sent to the respondents via certified mail to the address specified in Section 3 with a copy via email to the respondent's business owner, Keisha Anderson. After receiving the respondent's explanation, if any, the Attorney General shall decide whether the default has occurred, the number of defaults respondent have committed, and that decision may be binding on respondents. If the respondents fail to explain why a violation has occurred and or the Attorney General has determined that the default has occurred, then any and all remaining installment payments under the assurance will become immediately due and payable to the Georgia Department of Law, and the Attorney General shall send a notice of defendants demanding payment. This payment is in addition to and not in lieu of any other remedies available to the Attorney General under FBPA as a result of the actions that occur in violation of FBPA or this assurance. In the event the Attorney General determines that a default of the assurance has occurred, the Attorney General may immediately take any and all actions available to pursue enforcement and collection amounts owed to the Attorney General, less any payments received by the Attorney General. In the event the Attorney General determines that default of this assurance has occurred, the Attorney General may pursue all rights and remedies available under the law of the state of Georgia to compel the respondent's compliance with the relevant provisions of this assurance. Conclusion: the assurance of voluntary compliance, when accepted by the Attorney General, shall bind respondents and their successors and assigns who take with notice of the terms and provision thereof. Respondent hereby agrees to give notice of the assurance of voluntary compliance to its successors and assigns principals, officers, directors, owners, and employees/agents. The titles and headers used in this assurance are for convenience purposes only and are not intended by the parties to lend meaning to the actual provisions of the assurance. This assurance of voluntary compliance made and entered into by and between the undersigned parties is effective upon the date of acceptance. And we see signed, proposed, consented, and agreed by Keisha and Jeremy, LLC, Keisha Anderson, notarized, signed as company, signed as individual, signed by Christopher M. Carr, notarized. Okay. And let me tell you guys what this is real quick. Let me do it for Georgia. Let's see if that makes a difference. So a petition of assurance generally refers to a request or a formal application seeking a guarantee or confirmation of something. Basically, what I think this whole thing was or is that like it says at the very beginning, if you're just now coming in, just scroll back. We got started right away. So just scroll on back. Basically, what it's saying is that they are entering into a voluntary agreement with the state of Georgia because basically they got busted out for running a credit reporting service, and they are not allowed to do that. They're not allowed to offer it. They're not allowed to advertise it to consumers of the state of Georgia, and they're not to run it in the state of Georgia. That's it. It's basically, I don't even want to say it's a slap on the wrist. They basically signed a contract with the state of Georgia that they're not going to do what they've been doing, and they're going to comply with it. Also, in the face of, we're not going to seek criminal charges against you, but we are going to basically fine you. You're going to pay us $5,000. That's a binder for this particular contract. If you're out of order in the next 2 years, not only will we seek additional criminal charges against you, but you're going to also owe us that $10,000. Okay? Because the order's for 10. The order's for 15. You paid 10 and you owe us 15 in the next 2 years. In the next 2 years, if we find that you guys have violated, we're going to seek out legal repercussions, and you're also going to owe us the $10,000. Okay? Who said embarrassing? Someone said this is a mess, embarrassing, all the things. Yes. Okay. I had to do that. I'm just kidding. Right now, this is actually civil, sort of. It's somewhat criminalish, but it's on the civil side for right now. Okay. Where is my? Hold on. Is it right here? I want to have the right thing available. Okay. Can you believe this? Baby. All right, you guys. We'll talk about it. We'll talk about it again, I'm sure. I'm sure nobody is surprised here. We've all known that credit reporting in Georgia was not valid. You have to have certain regulation. You know, there's regulations. You have to have certain, I'm sure, certain licensure or certifications to be able to do it. And there's very specific criteria on how it's to be done. Really? Yes. I remember something about that. I didn't know if it was like this specifically. Okay. I just think I mean, I don't know. Based on that didn't we watch a video today where she was talking about they gave it away? Now that could have been before the date, but I'm chewing ice. Baby. I'm gonna see y'all down in the comments, okay? Hold on a second. If you want, can view. I mean, this is a public document on the Fulton County website. It's going to cost you a little cute coin, and not much. It's only like $7. But I got you. I'm going to make it a free download on my Patreon. Just go to my Patreon, Real Talk Bougie. Should I put it on the Patreon? Okay. Baby, look. The eyes, you know what I'm saying? Is today Monday? Under his eye? Girl, all I'm gonna say is the eyes under his eye, and girl, be blessed, not stressed, okay? Girl, be blessed, okay? Girl, bless be, thank you. Under his eye. Okay, if you're in the chat, there you go. Okay, it'll be on my Patreon. Okay, I love you guys. You guys have a good evening, okay? I'll see y'all tomorrow morning. Toodles.
Right now because of him. A lot of my credit repair customers because of him. If Jeremy promotes stuff out of me, like anything that, because I do a lot of things out here, and Jeremy comes home every day or contacts me throughout his day with somebody, whether it be credit, like, hey, somebody's looking to do this, babe. I talked to them about you, blah, blah. Like, when we close the deal, y'all see the closing video, but just still the point is, he really, really, really values me, and kudos for doing what you're supposed to do. Like, I'm a mom, I don't get kudos for it. He's a dad, but just like to just do it without any question, just because he just so me and wants me to win. So whichever room he's in, every room that he's in, since I've gotten my real estate license, he's this very moment. Just the fact of the matter is, I know this is a client. The goal is so we set up a plan and we get to that goal. Anyways, y'all, let me go ahead into this condo. We're going condo, y'all. Look at me. I came to the Finchies to get some lunch. Babe had sent me some lunch money. I was like,
okay, Miss Bond wants to know, is this criminal? It's a civil action right now. It's filed. Let me show you guys this. Am I still live? It's basically it's a non-criminal action. State of Georgia. Christopher M. Carr, Attorney General of the State of Georgia versus Keisha Anderson, LLC, Limited Liability Company, and Keisha Anderson. It's a civil action. It's non-criminal. It could go criminal if you just fuck around and find out. That's it. It's on some fuck around and find out. Okay. So go back to the beginning. If you're just now coming in, Miss Bond, it says that they are waiving any criminal filings, any further criminal action, because she's signing this this document agreeing to adhere to the law. Although even in this document, she maintains her innocence. She basically says she and her employees state that they have done no wrongdoing, but they are going to comply with the stipulations in this agreement. Just go back to the beginning. I kind of explained a little bit as we were going along, but I didn't want to inject too much of my opinion in the piece, but it's pretty self-explanatory. It's civil. If you break the law, continue to break the law, or don't follow these guidelines, it's not going to be civil. Does that make sense? It's not on a record because it's not criminal. She's basically engaging in a contract with the state that she's going to stop what she's doing and follow these directions. And this is basically somewhat of like a fine. If you want to break this agreement, number one, you're going to break this agreement because we have detailed to you what you're not supposed to be doing. Break the agreement, you're going to owe us the rest of the $10,000, and we're going to pursue additional legal recourse against you. That's it. That's all. Okay. All right, guys. We'll talk about it tomorrow. If you guys have some questions, drop them in the comments and I'll answer them. Okay. You guys have a good night, girl. I got to cook dinner.
Right now because of him. A lot of my credit repair customers because of him. If Jeremy promotes stuff out of me, like anything that, because I do a lot of things. I feel here, and Jeremy comes home every day or contacts me throughout his day with somebody, whether it be credit, like, hey, somebody's looking to do this, babe. I talked to them about you, blah, blah. Like, when we close the deal, y'all see the closing video, but just still the point is, he really, really, really values me, and kudos for doing what you're supposed to do. Like, I'm a mom, I don't get kudos for it. He's a dad, but just like to just do it without any question, just because he just so me and wants me to win. So whichever room he's in, every room that he's in, since I've gotten my real estate license, he's this very moment. Just the fact of the matter is, I know this is a client. Their goal is, so instead of planning, we get to their goal. Anyways, y'all, let me go ahead into this condo. We're doing condo, y'all. Look at me. I came to the Finchies to get some lunch. Babe had sent me some lunch money. I was like,
yeah, I might got a little deal for y'all people. If y'all, I might got a deal for the people without wheels.
So I think this is my last thought, and I'm gonna let y'all go. For whoever's still in here, I think someone must have complained. It's obvious, like someone had to have complained, but they specifically mentioned they know she does social media, and they know she's a YouTube content creator, and they know that she was promoting on her YouTube channel. Clearly someone had to have complained on her. Maybe that's who the troll was. I don't know. But at the end of the day, baby girl. Anywho, you guys tell me what you think. Comment down below. Go ahead and get the conversation going in the comments. I really appreciate. I love the engagement. You guys talk to each other. Okay. You listen to the whole thing. I encourage you, if you're just now coming in, go listen to the whole thing. I did drop the link. It does have my watermark on it. If you want it unwatermarked, be my guest. Go to Fulton County. You can purchase it at $7. I just gave it to y'all because I love you. Okay. And we're just doing we're learning about government. We're learning how the attorney general works. We are just citizens of the world out here trying to understand what the fuck is going on. Okay. So I got it for you guys, so you don't have to spend your coin. And and that's it. That's all. Okay. Bye guys. Have a good evening.